not legal advice. Good morning, good afternoon, or whenever you're watching this. Please like, please subscribe. So if you get anything out of this, please subscribe. You don't have to do anything else. I'm not asking you to send any money. I'm not asking you to send me a cake, although I would like a cake. So if somebody wants to send me a cake, please do so. Today, I'm going to briefly discuss kind of my view of Finra versus the SEC, which involves Sorrento, Alpine, MMTLP in particular. And we're going to talk about this in much greater detail with a live stream with JR on Sunday night. And then we're going to have, or we're scheduled to have, another live stream Tuesday night with Will Stewart, who some of you may know was the second largest shareholder of MMTLP. So he will be on with talking about, I can't imagine what he'd be talking about. I think he'd be talking about MMTLP, NextBridge, but I also think he's going to be talking about real estate, commercial real estate, etc. So we have that to look forward to. Currently scheduled for 7:30 p.m. on Tuesday, which would be August 1, I believe. So, and I'll let you know if that changes. And just a reminder, JR and I are doing a live stream on Sunday night, 6:30 p.m. And we'll address some of these topics and more in depth. So just a quickie, just to keep with the program. Russian dolls are so full of themselves. Anyway, I look back, obviously what's been going on recently is all the stuff involving Finra, the SEC, MMAT, MMTLP, and NextBridge. Been a concentrated actions that have been going on. First we had McKay, and I had referenced that I was aware of certain things that were going on. So I was aware generally and tried to give notice when I could of what I could. And I think there's going to be some other stuff, by the way, which I can't talk about either, and I'm not certain of, but I feel confident at this point in time that there'll be other stuff that will go on. But I started looking at recent correspondence and recent changes. So we had the dividend, I call it a dividend offering, which some people might construe as a way of ascertaining what the share count is. So with MMTLP, obviously they're like other tickers, GTII, Finger, AMC. There's tens and dozens of these tickers where there's not just alleged to be shorts, which is an ethical problem I have, period, but these are naked shorts, counterfeit shares, etc. So we're totally bogus and unlawful. So I'm focusing on MMTLP because MMTLP came out with this offering to ascertain that information. They also reference some communication with Finra, and I was aware, or at least had been informed of, that there may have been that communication going on, and there were attempts made to get action taken by Finra, and in the end, my understanding was that Finra elected not to take any action, as we see. And so it was interesting to me is NextBridge came out with their action, and although Finra has been virtually incompetent in all respects, have been slow to act, even in the Alpine matter, which I reiterate multiple times. Even after 35,000 violations, they've been slow to act and have not acted in a proper manner to protect the interest of the public. One day, literally one day after NextBridge sends out their communication, not only does Finra respond, but they submit 3 letters. And that's despite the fact that NextBridge did not include any of these letters in their submission. They sent out a notice of PR that I think all shareholders received, including myself. There's also the filing, and then the next day, Finra responds. And Finra sends out a couple of letters. So they include a letter that was sent out in April from NextBridge, basically on behalf of shareholders, although a little soft on just my personal criticism, not legal advice, has nothing, no value other than the fact I wouldn't have conceded certain points in the letter. I may have been a little stronger, but so be it. Their intention was to try to resolve the issues, and I understand why it was sent out maybe in softer tones than I would. But so there's a letter in April, and there's a response in May, and then there's a follow-up in June, I think in June. But the follow-up really doesn't add very much to it, and the letter from Finra that really is the responsive letter is dated May 19th, which is subsequent to their March. Remember, in March they had the FAQ. So this is another response. And so I looked at it, and this is one of the points I was going to reference today. I looked at it, and I looked at the first page, second paragraph, and so this is after they've received our contentions. This is after they put out the FAQ. This is after they put out the revised FAQ. This is after receiving the letter in April from NextBridge. This is a month later, and in the first page, it is such a confusing mess that it suggests, if you look at it, bottom paragraph, first page, if you look at it, it sounds like they are contending that the shares of MMTLP were converted to NextBridge shares prior to the time of the U3 halt. Now, I don't know, and read it over yourself. Maybe you'll draw a different conclusion, but the way it's drafted, it certainly suggests that. I don't know if that was unintentional or intentional, or they just don't understand. But it certainly, to me, was inaccurate, if nothing else. And again, here we have this SRO, not a government entity, who is acting multiple times incompetently at best. Really, at best, if they don't understand this information by now, and that's with counsel, probably executives reading over, then how can they do their job? It really was distressing, honestly, looking at this letter. And again, they didn't have to send out this letter. They didn't have to make it public. Perhaps they thought it somehow made them look good. However, their sequencing really is disturbing. So besides the fact I think they're showing further inaccuracies, the fact that they acted so quickly to respond really suggests the heat's on them. Because they haven't responded quickly to anything. So the fact that they reacted right away and filed suggests that there are people who are being a pain in the ass out there, such as all the people in these communities, that are causing them to act. Now, one additional point, and I'll discuss this with JR over the weekend, was they in essence say they couldn't, there was no structure they could set up to let the shorts trade as requested by NextBridge. But as we all know, in that Sorrento Therapeutics case, which is the bankruptcy case in Texas involving Skylex, where the judge not only found naked shorting, but signed off on an agreement whereby the naked short holders could buy out by covering at a price determined by a company favorable analyzer. So the person who was determining value was somebody who was at least aligned with the company, not with the naked shorters. So that being the case, and now that was approved by a court this year, maybe subsequent to May, however, so we'll give them the benefit of the doubt. So are they saying now, because a court has said it's okay to close out shorts in a naked short position, are they saying they will concede to that? Are they saying they will stipulate to that? Are they saying they will accept a judgment as to that? Are they saying they will participate in a court action to validate such action? Those are all important questions I'd like to see them answered. I'm skeptical that they would take advantage of that. A second really important thing that's going on here, I believe, just as important as the incompetence or corruption that seemingly exists at Finra, is with the Wells notice that was filed by the SEC, and that was at least the notice, the corporate notice was provided, so we know it exists, although we don't know the details. But the SEC knew from that they that they would receive a detailed response in some fashion, whether it be written or in person or both, contesting the allegation and charges, and that those particular allegations and facts would be directed at Finra primarily, because they're the ones who were involved. And I previously heard a couple months back probably that the SEC were pissed off at Finra, wanted them to resolve this particular matter, the MMTLP. They were getting pushback from various sources, and that they wanted it over. And they haven't been successful in getting that done. So interesting to me that they've put out this Wells notice, which they knew or had to know would engender some type of very detailed response, whether it be in the form of a complaint filed in court or just in a response that was in the form of complaint making allegations against Finra and what went on. And there's 3 potential responders who all could respond individually. Could be John Berta, who was one of the ones who received notice. Could be George Palikaris, MMAT, and it could be MMAT itself. All 3 got the notice, so all 3 can respond. So I would think that would be a very vigorous response that would be extremely anti-FINRA. So I believe, in light of what I heard before, in light of this action, I believe that the SEC has it out for FINRA, and that FINRA has to look over their shoulder, because I think that if they take note, they know that FINRA is out to get them, and they should be aware of that. And FINRA, you should not take actions involving the SEC without considering that first, because they aren't your friend, it appears to me. I'm not your friend either, but they've acted like they were in alignment because they had supervision over you. They haven't really supervised you, of course, but I think at this point in time they're throwing you to the wolves. So they're going to let you take a beating. You have no defense as far as I can see. You could say, whatever you've said in these convoluted letters. I understand your position, but I think it's a position taken in bad faith, and now without the support of the SEC and others, you're going to be very vulnerable. So I would suggest that you think of a way of resolving these situations in as expeditious a way as possible. And finally, and along the same lines, and again we'll address this a little bit, is there's a ton of momentum directing at limiting FINRA's authority, and for finding also eventually that FINRA is a state actor. And if they're a state actor, then they're subject to the same constitutional protections that all citizens are provided from the government. So to the extent there are due process protections that the federal courts have to provide, it may be the case that instead of the ridiculous arbitration system, which I'm involved with and have to abide by it and will aggressively pursue it as I can, perhaps there's new standards that might arise as the court cases get determined. And again, we'll talk about that Sunday night, but I really believe FINRA's authority in all respects, not just their enforcement powers, but in terms of how they deal with us as consumers and how they regulate or force arbitration, is being challenged. And new cases and rulings come out. I did look at, by the way, Alpine today. As of the 28th, there was no new filings. Last filing was on the 19th, and that filing said that FINRA had requested that the entire appellate panel consider the ruling of the 3-judge panel, and they are obviously trying to get the injunction overturned that stops FINRA from an expedited proceeding against Alpine. Obviously, I've suggested that FINRA still going to district court, and there's no excuse for them not going to district court. I will keep you updated as to Sorrento Therapeutics. Last and not least, I've called counsel that were involved in that case and emailed them and await a response. Hopefully I'll get a response, and we'll get some interesting information as to how they dealt with the naked shorts, what they did, etc. And if I receive any such information, I will pass it on. Anyway, have a great day, a great weekend. Maybe I'll see you Sunday night. Take care. Be well.